Every so often, every once in a while, the judiciary rises above it all and provides us a reminder of what our constitutional republic is all about. And we just got it with a decision by the Fourth Circuit Court of Appeals and its 3 judges to rebuke the Trump administration, but in poetic, soaring language that reminds, hopefully, everyone that we should be aspiring to our greater angels and not trying to leave a human being to rot and die in an El Salvadoran jail. We have this new order because the Trump administration improvidently went to the Fourth Circuit Court of Appeals and asked them to stay Judge Zinnes and her process that she's established to implement the 9-0 United States Supreme Court decision in her favor, to make sure that due process and the Fifth Amendment constitutional rights of everyone, including someone named Armando Abrego Garcia, are respected. And once she figured out that the government of the United States, who only wants their powers recognized, but not of the federal courts, that they were doing, in her words, absolutely nothing, or in the words of the Fourth Circuit before her, that what they were doing was unconscionable, she acted. And in a recent hearing, she said, we're going to get to the bottom of this. We're going to do some intensive discovery. Depositions are going to be taken. Cancel your vacations and buckle up, she told, literally, the Trump administration. We are going to get to the bottom of whether my orders and those of the United States Supreme Court have been violated. Well, Donald Trump and his happy band of constitutional violators didn't like any of that. And they ran back to the Fourth Circuit with yet another motion and asked for a stay to stop the judge from administering justice. And that they would not do. Do I have you on the edge of your seat yet? I'm about to read you the order, one of the most powerful and beautifully written that I have read in a long, long time here on Legal AF. Let's get to the order coming out of These are the 3 judges of the Fourth Circuit Court of Appeals, which sits over Maryland: Wilkinson, King, and Thacker. I reported on all 3 of them when they ruled 3-0 that Judge Zinnes was correct. And they said that she could order that the Trump administration immediately facilitate the release from an El Salvadoran jail of one Armando Abrego Garcia, who the government already confessed and admitted they violated his rights and violated another court's order by sending him off to El Salvador. So I'm not surprised that these are the same 3 judges that have now ruled in less than 1 day, and listen to what they have written. I'm going to start from the beginning with very little interruption. Sometimes you just have to read the words and leave it at that. It is difficult. The order starts on page 2. It is difficult in some cases to get to the very heart of the matter, but in this case, it is not hard at all. The government is asserting a right to stash away residents of this country in foreign prisons without the semblance of due process. That is the foundation of our constitutional order. Further, it claims in essence that because it has rid itself of custody, there's nothing else that can be done. This should be shocking, not only to judges, the 3 judges wrote, but to the intuitive sense of liberty that Americans far removed from courthouses still hold dear. The government asserts that Abrego Garcia is a terrorist and a member of MS-13. Perhaps, but perhaps not, meaning the record's not clear. Regardless, he is still entitled to due process. Moreover, the government has conceded that Abrego Garcia was wrongly or mistakenly deported. Why then should it not make what was wrong right? They then go on to the Supreme Court decision and talk about what facilitate means and why we have 2 governments doing no part of facilitation. El Salvador on one side and the Trump administration on the other. And they talk about on page 3 of their order that the word facilitate is an action word, an action verb. It has a plain and active meaning that cannot be diluted by its constriction as the government would have it to a narrow term of art. Facilitation does not permit the admittedly erroneous deportation of an individual to one country's prisons that the withholding order forbids, and further to do so in disregard of a court order the government not so subtly spurns. Page 4. The government is obviously frustrated and displeased with the rulings of the court. Let one thing be clear. Court rulings are not above criticism, says the judges. Criticism keeps us on our toes and helps us do a better job, citing the very famous Supreme Court Justice Frankfurter, who in 1958 wrote, criticism need not be stilled. Active obstruction or defiance is barred. They then go over the power of the executive branch, the energy of the executive branch. The executive, they say on the bottom of 4, is inherently focused upon ends. The judiciary, much more so upon means. Ends are bestowed on the executive by electoral outcomes. Means are entrusted to all of the government, but most especially to the judiciary by the Constitution itself. On the bottom of page 5, after talking about the enormous power and the fact that 2 governments are disclaiming any authority or ability to return Abrego Garcia, citing back to the bilateral meeting press conference in the Oval Office a couple of days ago, the 3 judges wrote, "The basic differences between the branches mandate a serious effort at mutual respect. The respect that courts must accord the executive must be reciprocated by the executive's respect for the courts." Isn't that what we're missing right now? Isn't that what's lacking? Donald Trump is all about Article 2 power, but he doesn't acknowledge Article 1 power of Congress or Article 3 power of the courts. Too often today, the opinion goes on, this has not been the case, as calls for impeachment of judges for decisions the executive disfavors and exhortations to disregard court orders sadly illustrate. It is in this atmosphere, they continue on page 6, that we are reminded of President Eisenhower's sage example. Putting aside his personal opinions, President Eisenhower honored his inescapable duty to enforce the Supreme Court's decision in Brown versus the Board of Education to desegregate schools with all deliberate speed, meaning his own opinion was, I don't want to desegregate the schools with all deliberate speed. But he said, I'm going to put that aside because that's what the Supreme Court ruled. That now they continue. The branches come too close to grinding irrevocably against one another in a conflict that promises to diminish both. This is a losing proposition all around, 3 judges wrote. The judiciary will lose much from the constant intimations of its illegitimacy, to which by dint of custom and attachment we can only sparingly reply. The executive will lose much from a public perception of its lawlessness and all of its attendant contagions. The executive must succeed for a time in weakening the courts. The executive may succeed for a time in weakening the courts, but over time, history will script the tragic gap between what was and all that might have been, and law in time will sign its epitaph. It is, as we have noted, this is now going to be the most famous quote, I'm sure will be in history books and in the way historians write about this and in law school texts. This is the final concluding paragraph. It is, as we have noted, all too possible to see this case as an incipient crisis, but it may present an opportunity as well. We yet cling to the hope that it is not naive to believe our good brethren in the executive branch perceive the rule of law as vital to the American ethos. This case presents their unique chance to vindicate that value and to summon the best that is within us while there is still time. And by the way, your motion for a stay pending this appeal is denied. They also say right up front that they are not going to micromanage the efforts of a fine district court judge attempting to implement the United States Supreme Court's ruling. What is the United States Supreme Court going to say about that? They couldn't write anything more powerful and eloquent and pithy in getting right to the heart of the matter. This is not just about Abrego Garcia. And they're right. It's not about whether he is or is not MS-13 part of the gang. It's not about whether he and his wife had marital problems and domestic violence in their marriage. It is not about what happened to other people who might have suffered from a crime committed by the undocumented. This is about our rule of law and our co-equal branches of government. This is about whether an executive branch is lawless or not, and whether the judiciary has the gravitas and the respect ultimately of its other 2 co-equal branches of government to do its job. That is what this is about. You could strip the names off. They don't matter. I mean, they matter to the families. They matter to me. I like to get the guy out of, bring him home after 33 days of being in a dark, dank, supermax killer jail that he shouldn't be in. However, this is about greater principles. Most cases that end up at the Supreme Court should always be about greater principles. And as the arc of history bends, our greater angels are the ones that need to lift us up. That is, we should be siding with the angels and not otherwise. And that is the clarion call that these 3 judges are making. And they come from different administrations. You got Republicans and Democrats in this panel, Wilkinson, King, and Thacker. You do. I mean, there's no Trumpers in there, but I've been doing this a long time. I've been reading a lot of decisions and orders and opinions since I was in law school, if not before, and for the last 35 years and for the last 5 years on Legal AF. That will go down for me in the pantheon of some of the most powerful and moving statements that have ever been written, and hopefully will be cited and quoted in future briefs moving forward that we will cover here on Legal AF. What's going to happen next? There's an appeal. They're going to deny the appeal. Judge Zinnes has already set the course of discovery, depositions, and questions under oath that need to be completed over the next 2 weeks. She will then consider a motion for contempt against the Trump administration. It could be their second one. She's already invited if there is any gamesmanship or any bad faith by the Trump administration, it's starting to be their middle name. She will entertain an emergency order for sanctions against the Trump administration. You can be sure and bet dollars to donuts that's going to happen. And then from there, the United States Supreme Court is going to get back in. We've already heard today that they're going to hear 2 cases for the Trump administration in the middle of May. One of them on birthright citizenship and the other one on whether courts can issue nationwide injunctions. Two things at the top of the list of the Heritage Foundation checklist for Donald Trump that are going to be heard by the Supreme Court. Come back here on Legal AF. We're doing live streams of all of the oral arguments at whatever court about the Trump and Trump administration policies. We already did one today about the Associated Press and the challenge to the First Amendment in a 3-judge panel in D.C. with a live stream, and we were joined by about 40 or 50,000 people. We're going to continue to do that with commentary before and after, only on Legal AF. Take a moment, hit the subscribe button. Now, if that did not move you to subscribe to Legal AF, I don't know what will. So until my next report, I'm Michael Popok. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touches Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok Firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok Firm, fighting for your justice every step of the way.